I've done it that way. Someone else might be able to, I don't know about you guys, they might be able to.
Yeah, President, what you're referring to is Commission Rules 80112. It says that any provision concerning payment of commission or compensation, including the forfeiture of such, shall not be included in the offer of purchasing contract.
Right.
So we're curious if that applies to
I put it
lease.
in, I put it in the lease agreement. And I don't think that's different from the offer of purchasing contract. Right. No.
Thank you on that. My other question, is this a situation where instead of being able to go to small claims court, you would have to pay if a lease purchase falls apart due to a buyer's non-payment type of thing, that the seller would have to go to district court because of the size?
Sure, absolutely, yeah. It's great.
Expound on that?
That's a great question, because the small claims court is only for $4,000. If you're going after money, it's $4,000 and below. So anything over $4,000 is going to go to district court.
And what's the time span on that?
For district court, I haven't done any work in district court. I know in the small claims court for the summary ejectment, it can take upwards of 45 days to be able to get judgment for money owed and get repossession of the property back with the tenant out. So it's a pretty long time.
Thank you.
Thank you.
John Langberry with Prudential Carolinas. Frazier, you're on the spot today.
I figured I would be.
My understanding that if you do a lease purchase where part of the lease will go back to the purchase price, that this will affect the type of eviction that you can place because the courts consider that now the renter or lessor has ownership in the house because half of their rents have been going to the purchase of the house.
Well,
Can you elaborate on that?
Sure. I don't know if this will answer your question, but those won't be going back towards the purchase price to closing. So it's basically, $1,200 a month, $200 of that's going to be applied. If it's a 1-year lease, then $2,400 will be knocked off the purchase price of closing. I mean, I don't know. I haven't run across that in the eviction court where they say they have an interest in the property. They have a leasehold interest, obviously, in the property. Yeah. Just as far as the deed, you have to transfer it. So there's no legal ownership other than a leasehold interest.
But the lease may be recorded on the deed already. And it's,
The lease, and that's what I mentioned with the memorandum of lease. It's a good idea. It's good practice to have that recorded, just so if Mr. Seller goes and tries to sell the property for a higher price and they do a title search, it shows up there and protects the buyer. Thank you.
Hey, I'm Matt Reyes. Hey, Frazier. First, I'd like to thank everybody for putting together what's been a really great presentation. My first question, you talked mainly about lease purchases. I've done several different lease options.
Sure.
Is there a liability or a risk prevention reason why you recommend a lease purchase over a lease with an option?
Oh, not at all, not at all. I mean, I do both of them. I just focused today on the lease purchase, but I do the lease with the option to purchase as well. It's very simple.
Okay. So my other
Same
question.
liabilities.
Gotcha. My other question is, you talked about completing an offer of purchase to go with the final contract. What I've been doing is when I get two parties together that are a seller that wants to do a lease option or a lease purchase and a buyer that's also agreeing to that, I've been going right to an attorney and saying, okay, these two parties want to complete this transaction, you write the contract.
Yeah.
I'm not completing an offer of purchase or any of that.
And that's usually what happens is, you guys as the agents will hammer out those terms, and I can put them both together and then send them back out together with, Exhibit A as the offer of purchase, so everybody's signing at the same time. And I've done that before, and that's, it's not a problem for me. I'm happy to help out.
Just one other thing that people may be interested in hearing, what I've been doing on commissions is if the agreed upon commission in the listing agreement was 6%, then my fee for completing that is 3% at the signing of the contract, and then 3% on the back end, and that's been working pretty well. If there's another agent involved, then obviously we would split that,
Sure.
so we have an agreement. So thanks.
Thank you.
And I've got 2 questions for Frazier and 1 for Dana. Frazier, this also is a question about the lease purchase, because what we're finding is that when we have a purchaser that is interested in doing lease purchase, the listing agent will say, okay, well, just fill out the offer to purchase, and then fill out a lease, and then take it to the attorney who drafts a 3rd document that connects the 2. And my understanding from you is that that is not the way to do, that actually we would fill out the purchase agreement, but then the 2nd document would not be a lease, it would be a lease purchase document. So
Correct.
there would still be only 2 documents.
2 documents.
Okay.
It's the total, the complete title is a lease with an agreement to purchase, and that's the lease, that spells out the lease portion of it,
Mhm.
and the obligation of the buyer to buy at the end of that term.
Okay, yeah, there's this perception out there that there's a
Yeah.
lease and a purchase and then the 3rd document that connects them. Yeah. All right. The second question is now, then when we're filling out the offer to purchase, obviously in that lease purchase is going to have the provision for option money, which is non-refundable. So, in the offer to purchase, under the earnest money, do we put 0, since we've got that option money already?
No, the earnest money is going to be completely different. The earnest money is going to apply to those items in that offer to purchase and contract. You know, if there's a financing contingency in there that's not satisfied, the deal falls apart, the buyer's going to get that back. Whereas this option, or what you're calling option money, last call deposit, is going to be, it's separate and apart. That's for the seller to take this property off the market, and then closing will be credited back towards the purchase.
Okay, then would this earnest money be sitting in the listing broker's trust account for
Correct.
however many years until it closes?
Correct. Correct. That's the way I see it, yeah.
Okay, and it's just, the amounts are just negotiable between the 2 parties?
Absolutely.
Okay.
Absolutely.
And then my question for Dana, I'm also on rental properties, so like, when you said that if there's an arrest on the property for drugs, then if you don't start the eviction process in 30 days, then they can seize your property. That, I had no idea. So my question is, what if you've got a perfectly good little family in the house, they're paying their rents and everything, and some unrelated party is arrested on the premises, they're not on the lease, then does that rule about, 30 days still apply if it's not someone that's actually in the property that has been arrested for drugs?
The 30-day rule is a rule by the DEA that, well, the DEA had it passed in Congress. What the rule basically says, if they rearrest somebody within 30 days for the same activity, they have the right to confiscate the house,
Regardless of whether that person is on the
regardless whether they live in the property or not. So
Okay.
your job basically, and by the way, part of the criteria is they got to notify you. So if they didn't notify you, then they arrest the person a second time, they can't confiscate. So if they did notify you, you need to immediately start eviction process.
Oh my gosh.
Whether that person is, we had a situation in which I
If it had
helped a
nothing
lady.
to do with the people that are living
No,
there?
no,
Wow.
they're arrested on the line. So it could be somebody visiting.
Thank you.
I have 2 questions.
You're going to frisk your visitors from now on.
You touched upon, in the event of a lease purchase, the seller is foreclosed on. If the tenant is in, are they obligated to continue to pay rent as long as they continue to occupy, even though they know the foreclosure is pending? Or can they withhold that and just stop paying instead?
As soon as the foreclosure process is started, it terminates that lease. And so they're done.
So that means they need to vacate immediately?
What's that?
They need to vacate the property immediately? Because now, if you say if it terminates the lease, then now they're living somewhere without a lease.
Sure, yeah, well, it would be a violation of, the seller would be breaching the lease by having his house foreclosed on, the way I drafted it. So, yeah, I mean, they're gonna have to get out of the property.
Okay, and as I was waiting here, I thought of 2 parts to my second question.
Sure.
I may only get through the first part, but I'll read the second part. First part's for Debbie. There's a bullet here that says that the compensation has